Foreign funds can breathe easy, at least for now. The Bombay High Court today stayed the taxman's demand to Aberdeen Global Emerging Markets for payment of minimum alternate tax or MAT. The tax department has now been told to file its reply in this case by the 18th of June this year. Remember, there are at least 5 more foreign portfolio investors who have moved the court against the MAT levy.
Remember, the government and foreign funds have been at loggerhead ever since Finance Minister Arun Jaitley denied the retrospective benefits for MAT props announced in his union budget, which kicks in from the current fiscal. At a time when the Modi government was going all out to reassure foreign investors that tax terrorism is a thing of the past, the row over MAT vitiated the atmosphere all over again. The jury is still out on whether today's judgment will apply to all MAT claims by the taxman, but it is sure to lift the mood on Dalal Street.
We're joined by two of India's finest tax experts, Dinesh Kanabar of Dhruva Tax Advisors and Ketan Dalal, joint tax leader at PwC India, both joining us live right here on Business Tonight. Mr. Kanabar, of course, joins us right here in the studio. To you first, Mr. Kanabar, how much of a setback is this for the Income Tax Department, in its efforts to actually impose levy MAT on foreign portfolio investors? How much of a setback is this for the Income Tax Department?
So, if you see what has happened today, the matter was argued before the Bombay High Court, and the issue before the Bombay High Court, which was agitated, was that when an order of assessment is passed on a foreign company or where there is a transfer pricing adjustment, there has to be a draft order, and the draft order can be either accepted by the SSC and challenged before a Commissioner of Appeals, or can be taken to a dispute resolution panel. Without following that, a final order was issued. And the principal thing which seemed to appeal today to the Bombay High Court was that that process had not been followed, and therefore the Bombay High Court came back to say that there is no alternative remedy to the action of the tax office, that they have passed a final order without first passing and a writ lies when there is no alternate remedy. So the writ was admitted, the tax office was asked to file a reply, and the process against Aberdeen was stayed. So in a sense, it's a big victory for Aberdeen. But that said, the Bombay High Court has really not gone into the merits of the matter at all as to whether an FII is or is not liable to MAT tax. We would all as experts like to believe that there is no case that the tax office has, but that's a separate matter altogether. But today's judgment does not really take that controversy any further. There is a matter fixed up tomorrow, and if that does come up tomorrow, there are, if I understand, 4 more writ petitions which have been filed, where the issue may not really be the technical issue of a draft order versus a final order, but really the merits of the issue, and it will remain to be seen how does the Bombay High Court deal with that matter.
That's a very fair point that you're raising, Mr. Kanabar. And Mr. Dalal, I'm curious to ask you this question. The point that he alluded to, that this is really on technical grounds more than getting into the policy framework, really. It was because a draft assessment order did not come in, the court found it favorable to go ahead and stay the levy. The question really is, the 4 other petitions, the 4 other writs that he's referring to, will this have a ripple effect automatically on other FIIs? Is that a fair conclusion to draw at this stage, Mr. Dalal?
The Bombay High Court has passed an order on technical grounds, and as he mentioned, it is not that it has been dealt with on merits. Of course, when the matter comes up, and some of the matters apparently are coming up tomorrow, and the Aberdeen matter also will come up on the 22nd of June. At that time, we will get clarity. Also, as Porus mentioned, the Castleton matter is there in the Supreme Court in September. So, insofar as the merits are concerned, vis-a-vis what the Bombay High Court has decided today, one cannot come to a conclusion that the matter is going favorably. But on first principles, as many tax experts, counsels on your channel and otherwise have been mentioning, if you see the history of MAT and the explanatory notes to the Finance Act, which is the rationale when the law was introduced, it is abundantly clear that MAT should not apply to any foreign companies, not just FIIs. It is any foreign company, whether it's a private equity fund or whether it is any company other than an FII or a private equity fund. As Dinesh mentioned, it is only when you maintain books of accounts in India that MAT was supposed to apply. So I think this whole controversy, very unfortunately, has been blown completely out of proportion. And if I might use a term which I heard and liked, it's like a manufactured controversy. It has sort of very unfortunately arisen, and I dare say it has arisen at a very wrong time when a lot of positive things kept sort of emerging or were emerging from India, and then this kind of thing pushes us back.
This kind of thing does push you back, and especially many questions being raised of the government's own handling of taxes and whether they're being misunderstood of how they're handling it. But Mr. Kanabar, if I may throw this back to you, because the order does give a stay, whether it's on technical grounds, whether it's getting into the details of policy, that's again very debatable, but it does give a stay. Will we expect the sentiment to change from here on? I mean, everybody's been talking about how spooked FIIs have been, and which is why we saw sharp corrections in our own indices. But should this be a sentiment booster of sorts, even though it's a stay on technical grounds?
Supriya, I am a tax expert, not an expert on how markets should or should not behave. But all that I would say is that...
I'm sure you've been speaking to a lot of those FIIs and advising them. Yeah.
No, but I think that the real key issue is, I think we are a long way away from resolution of the controversy. To resolve the controversy, I think what we need is a Supreme Court judgment. And as was mentioned earlier on the show, it's in August that the Supreme Court is going to hear the Castleton matter, because even the Bombay High Court judgment, assuming that's a favorable judgment, is likely to be contested in the Supreme Court. It's really the Castleton judgment matter which will be heard in August, where the Supreme Court will come back with whether or not foreign company is liable to MAT. I think if I can just explain this whole controversy maybe in a sentence, there is a difference between dealing in a country and dealing with a country. So when you are dealing in the country, you have an office, you have a permanent establishment, you are required to maintain records in the country, and therefore you are liable to book profit tax because you have books, and book profit tax is required to be computed. When you are dealing with a country from overseas and you are earning income, which is sort of a one-off income, whether it is capital gain, whether it is royalty, and in such a case, MAT tax ought not to apply. Unfortunately, what happened is that we made this amendment prospective, and when a representation was made that this is likely to give rise to a controversy, that other items of income are also liable to MAT, those were specifically exempted rather than looking at the lacuna in the law. And I think that is what Castleton's judgment of the Supreme Court will clear. Because if the Supreme Court was to hold, as we would all like to believe, that when you are operating with the country, not in the country, you don't have a base here, you don't have a permanent establishment here, you don't have to maintain books of accounts, then MAT tax does not apply, then whether it is FIIs, whether it is private equity, whether it is anybody else earning any other type of income, would not have any liability to MAT tax. And that is something which we are all looking forward to. Also, if I may just make one point, somewhere in the line, maybe the government needs to come out from this entire thing to say that let the courts resolve. Indeed, court resolution is available all the time. If that was so, that does not take the matter any further. I think the key issue is, can the government be pragmatic, really, and resolve matters without having to get litigated over the years?
Mr. Dalal, Mr. Kanabar made an interesting point about, why the government chose to keep it prospective. But, the justification that the government has given so far is that they had no choice but to do this because otherwise the tax demands would have been time barred. So in a sense, they were left with no choice and they could have been accused of not acting, which is why they had to issue these notices. Does that cut ice with you? Or do you think the government should have just gone ahead and, done it in a clean slate and say that we won't do it prospective, retrospective, whatever be the case?
Yeah, I think as Dinesh mentioned, the issue is not really of a court decision, because in every point in law, you will have some decision, some stray decision here and there, which is either in favor or against. And I'm not saying right, wrong, etc. But to base a policy on the basis of a decision is like having the tail wag the dog rather than the other way around. I think the more pragmatic view would be to say, does it make sense? As I said, I don't think it makes sense for MAT to be levied on foreign companies at all. And insofar as the very fact that they have amended the law for the future is itself an indication. Now, if that should be the law for the future, why should it not be the law for the past, when the government itself did what it did in the Vodafone case and took back the retrospective amendment 50 years and said that, well, this was our intent in 1961, where nobody could have even thought of such a matter. And now, when you are actually amending from now, I think it is possible to have a clarificatory, it's not actually even retrospective, it is a clarificatory amendment to reiterate what is anyway the position. So that is one point. So I think it does not cut ice. I know it's a long answer to a short question. The other point which I do want to make sure that this is understood and put in perspective, if we have tax treaties with a large number of countries, then, unfortunately in the press and on the channels, the reference is only to Mauritius and Singapore. But take the treaty with US and UK and remember that 50 to 60% of FII investments are coming directly other than from Mauritius and Singapore. Even where we have tax treaties, and even where the capital gain clause of those tax treaties says that the taxation would be as per domestic law, even then I think the government should expressly clarify, and this does not even need an amendment in the law, it just needs a statement to say that for treaty countries in any case this does not apply, even for the past. That itself will give a lot of relief to international investors, because a large number of them are anyway coming through treaty countries, including countries where the capital gain clause may be silent, but it is still a treaty country. Right. So I think there are many pragmatic things that could be done. I think what is worrying investors is the uncertainty.
Right, worrying investors is uncertainty. But, closing comments, Mr. Kanabar, why this fuss in the first place? Here is a government that promised that it will end tax terrorism. It promised that it will bring clarity and consistency of tax laws. And it's not even a Vodafone-like battle where the stakes are very high. What are the stakes there? As things stand, some 600, 700 crores, if I'm not wrong. So it's not even as if the stakes are very high. Given the collateral damage, why get into this in the first place? What's gone wrong?
Again, I'm not getting into the politics of it, but just look at what happened. It was FIIs who went and represented that, look, there appears to be a lack of clarity on the subject. Can you please clarify that we are not liable to MAT tax? Now, the government made a law and made it prospective. And it is not at all, as Ketan rightly pointed, about prospective or retrospective. FII's position was, we are not liable to MAT. You know this. Please put it in law so that we don't have to litigate. Now, what you did was to say it will apply in the future. We refuse to talk about past because we will now not retrospectively clarify anything favorable. It's not about, you are not doing a, was it government's intention when they amended the law saying that in future MAT will not have to be paid, that they were giving a concession? Far from it. They were really saying you are not liable to something. Now, therefore, it's really government digging its heel.
So it's double speak.
Rather than double speak, I'm saying government is getting caught in its own thing. It's like going round and round in a circle rather than coming straight to the point to say we believe FIIs don't, or why FIIs, a foreign company which has no presence is not required to pay MAT tax, and simply say this is the position. It actually didn't even need an amendment to the law. It maybe just needed a circular. You made an amendment to the law and made it prospective, and rather than say it always applied, you dug your heels for the past.
Mr. Dalal, I'll let your last word on this. Is this mishandling of the tax matter, specifically on this issue by the government, or is this lack of understanding of this very complex issue that North Block seems to be grappling with? I know I'm putting you on the mat, all pun intended on this one, but I do need an answer. Is this mishandling or not enough understanding of the tax matter?
Well, Supriya, I don't know what is the difference between the two, but I think as both Dinesh and I have pointed out, and many other experts as well, I think the important thing is to have what I would call conceptual, in principle clarity and logical thinking of not what is as per a decision of, but what should it be. And if what should it be is anyway clarified in the law going forward in the future, then why not for the past? I don't think that cannot be done. So as I said, mishandling or lack of handling I think is not the issue. And the other thing is, I think we keep on saying the government. But I think many of these things are unfortunately sort of a bottoms-up scenario. So it is not that the people in North Block or the CBDT or the ministry decided to do this. I think what actually happened on the ground was that a few tax officials took the stand that they did, and like an Ebola fever, it just caught on. And before anybody realized, it just has snowballed into the kind of controversy that we are now looking at. And you now have a government now trying to address that issue. And as I said, they have done at least for the future, and I wish they had also done a clarificatory amendment for the past.
That is so true, that New Delhi speaks one language and people down under, like you talked about the bottoms-up approach, completely have another dialect to talk in. Thanks very much to the finest tax minds here in India, Dinesh Kanabar and Ketan Dalal, joining us right here on Business Tonight on ET Now. Appreciate you taking time out this evening and clarifying what is really a big development as far as India's taxes is concerned.